I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my joyous co-host, Brett.
Oh, I am joyous. Oh, that's nice. Where'd you get that? Well, is that connected to the discussion today, or is it just
not at all?
Just came up with that?
Not
oh, wow.
At all.
Okay, it actually is about me.
It is actually about you because you know what? I was just saying before we started recording, there is a lot happening in the true crime world on cases that have drawn a lot of strong feelings, shall we say, from people, which is great. Look, if something happens to me, I want my case to draw a lot of ire from all sides. I want conspiracy theories to abound. Not only that, but I think there's just a lot happening in the world, and I just want to give everyone a big hug. But not you, Brett, because I can't really reach through. I can't. You don't need a hug. But we could all use a little bit more joy. And that's what I love about what we do here on Legal Briefs. There's so much that happens, and it's a matter of perspective. You can talk about these cases, and you can be hair on fire with every new kind of headline that comes out about a case and think the world is falling apart. Or what we try to do here is to explain what's happening, and for the most part, the world is not falling apart. Today, I'm going to say, this beautiful day that we're recording is not a day that is falling apart. So I choose joy.
Yeah, well, we're going to talk about 3 cases that are very divisive. Maybe the second one's probably the least divisive. There are some people who are divided by it, but at least 2 of them are very divisive. But there's been a lot going on, like Alice said. And so there's been some updates in these cases, and these are cases that you guys are interested in. So we thought, hey, let's talk about them, and hopefully everyone will enjoy it. The first of those cases, Alice, I don't know if you have anything else before I go ahead and dive in.
You should really dive in because there really are a lot of updates on three cases that people do feel very strongly about. And I will say this is another thing that we always try to do. We always try to link to the primary records, right? We're usually reading court documents. Because one of the things I find really frustrating whenever someone says, oh, did you hear about what happened in Delphi? I'll quickly search it, Delphi News. And there's other people's takes on it, but no one will link to, say, the court document that will tell me everything about it. And so I do find that frustrating. By the way, if you're a journalist, start doing that. Start linking to your primary sources.
Yes.
Please do that. First of all, it makes you a better journalist because other people can check you on it. And that's how every other peer-reviewed entity does it, right? When you publish an economics peer-reviewed journal article, you have to show your work and show the data that you're working with. Why don't we do that in journalism right now? So that's a little challenge to our friends who do report on these cases. Just link to the court order or the docket number, or give it the case number, or even just use the correct terms to describe it, because I think a lot of the confusion comes from not knowing what you're reporting about, and then it's a game of telephone down the line.
Look, there's no reason that they shouldn't link to the court documents. I mean, if they've read the court documents, which I would hope they're doing, if they're reporting on it, they can do that. It's the easiest thing in the world these days. But at the very least, the last line should be, the filing was made in the case of such and such with such and such number in such and such court. So somebody can look it up themselves. It's so annoying. But there are very few. Law and Crime's actually pretty good about it. If you get a Law and Crime, a lot of times you can find the documents. Well, this is all on the side. Do want to talk about, we'll dive into these cases because we have 3 updates and don't want to keep you here all day. So we'll start with Delphi. Actually, had no intention of even discussing this, but I was listening to the Murder Sheet. If you haven't been listening to the Murder Sheet, by the way, their interviews with all the different players in the Delphi case, just incredible. But I was listening to the Murder Sheet, and Anya was complaining about the fact that she didn't understand why, or she said, at some point we all have to live in a shared reality. And when she said that in discussing one of the recent Delphi filings that we mentioned briefly in a previous episode, something clicked for me as one of the problems I have with this case. And so I think this is sort of a global thing we can talk about. So we can talk about one particular aspect of that filing and why I think one of the big problems I have with both the Delphi attorneys and the coverage of the case. So you may recall this was a filing made by the defense that essentially was, hey, here's a bunch of errors we want to appeal at some point. And it listed a few. One of them was there's this confession by Ron Logan that should have come in. There was this video of the white van. And we think, it's kind of funny, because they're like, we think in this video the white van is arriving 15 minutes after it would need to be consistent with the prosecution's theory, which is just wild that you would actually include that 15 minutes. I mean, we wouldn't think it was like 3 hours, right? But 15 minutes is the best you can do. And they have no reason to say that other than just a pure guess. They have no idea when this tape was recorded. And in fact, it basically, I think, proves that the white van absolutely existed and was there at exactly when Richard Allen said it was. But that's an aside. That's not what I want to talk about. What I want to talk about is there was a stage at the very beginning of the case. You may recall Richard Allen, there was a safekeeping order that was entered because the jail that he was going to be in was very small. And obviously, this is the kind of crime that gets you stabbed. So they wanted to protect him. They sent him to a prison. And during that period, according to this filing by the defense, and remember, this is all the way at the beginning of this, but according to the defense, Richard Allen essentially had a secret lawyer that no one knew about. And that lawyer had been hired by Richard Allen's wife. Now, a couple interesting things about it. There's no affidavit from the lawyer. There's no affidavit from Richard Allen. There's just his wife saying, yeah, I hired this lawyer. And their whole theory of this was that because he had a secret lawyer, but the secret lawyer wasn't present at the safekeeping motion hearing, essentially everything that happened after that was illegitimate. So it was like you have to throw out everything that happened after that and start over. This was their theory, an insane theory, the kind of theory that a first-year law student should know is ridiculous. But they filed it, and it's just so frustrating. And I was thinking about this shared reality that Anya was talking about, and it made me think that the thing that is different, I feel like, from the Delphi case, from all the other cases, is you might disagree with the strategies and various things, what defense attorneys are doing, like Karen Reed or whatever. But we do exist in a shared reality in almost every other case where we have precedent and we have cases and we have law and we're acting within that. We're making our arguments within that. And I feel like that is where Delphi is different. The defense attorneys in Delphi and the people who comment on it act as if this shared reality of precedent doesn't exist. And so they make arguments like this. And this was really crystallized for me by one of the commenters on Twitter, who is an appellate attorney who doesn't believe he landed on the moon, was trying to argue why this works. And her explanation was, well, at a critical stage of litigation, you have to have an attorney. And this was a critical stage because since he was sent to the prison and that's where he ended up confessing, if he'd never been sent to the prison, then maybe he never confesses. And so therefore, this is a critical stage. And it's like, that's not right. Like,
create
critical
a post-hoc
stage.
critical stage.
Exactly. Exactly. You can't.
Right. That's post-hoc because what if I just went to a bouncy house? We've talked about bouncy houses before. I'm jumping in a bouncy house and I confess in the bouncy house post hoc. That bouncy house was a critical stage.
Critical stage. And the thing about it, what she knows and what every lawyer knows is that critical stage is a term of art. It is something that means something in the law. If you're a lay person, you hear that and this is what they do. Even though they know the definition of those words, to confuse and mislead lay people, they act as though those words have just their ordinary meaning. Well, of course, it was a critical stage because it ended up being important and things happened because of it, right? Well, that's not what it means. So let's talk about the actual shared reality that they should be operating in, but they refuse to operate in. What is a critical stage of litigation? Well, of course, it's defined. So we've talked about this before. You have a right to counsel. Now, that right is limited, and we've talked about different ways in which it's limited. And it's also limited as to when you have a right to counsel, as we've talked about before. For instance, in a 2255 or 2254 or a habeas corpus action, you do not have a right to counsel. That's an example of when you don't. Now, you might think that sounds like a pretty critical stage of litigation, right? Your collateral attack of your conviction, your claim that it's unconstitutional. Well, it's not, because that's not what the word means. So essentially what the Supreme Court has said is you have a right to counsel at critical stages of the litigation, and it has to be a part of the trial that would, quote, impair the defense on the merits if the accused is required to proceed without counsel. So it has to be a stage in the trial, which, as Alice said, we know before it happens. This is not dependent on the facts, but dependent on the type of thing occurring, that is a circumstance where you could lose some rights forever, impair your defense forever. So some examples of that: an arraignment, where you appear for the first time and you say things like not guilty or guilty. Obviously, if you don't have an attorney there, you can understand how that's a critical stage. That is where you are saying for the first time what your plea is. A change of plea hearing, which is like an arraignment, but where you're going in to say, you know what, actually I am guilty. Things like post-indictment interrogations. So after you've been indicted, you then have the right to an attorney in that post-indictment interrogation. Trials, sentencings, those are what's considered critical stages of the litigation.
This episode is brought to you by Progressive Insurance. Do you ever think about switching insurance companies to see if you could save some cash? Progressive makes it easy. Just drop in some details about yourself and see if you're eligible to save money when you bundle your home and auto policies.
The process only takes minutes, and it could mean hundreds more in your pocket. Visit Progressive.com after this episode to see if you could save. Progressive Casualty Insurance Company and affiliates. Potential savings will vary. Not available in all states. Guys, we want to talk about one of our favorite podcasts, a podcast we love so much we have appeared on it multiple times. Silver Linings Handbook with Jason Blair. Jason is a friend of ours, but he's not just that. He is an incredible interviewer, an incredible podcaster, and his episodes will pull something out of you you didn't even know was there. He says that he wants to have conversations that inspire, and he does just that with interesting conversations with interesting people. And the themes that he looks at are not just true crime, though he's got a lot of great true crime episodes as well. He talks about growth, understanding, belonging, compassion, things that are important in true crime and in life.
And you guys, even if you think you've heard something before, Jason is able to bring out things you never thought about. Just check out these recent episodes. He had an interview with Kimberly Loring, the sister of a 20-year-old missing Montana woman, Ashley Loring Hevinretter, and about her search for her sister, finding faith in God and forgiving those who harmed Ashley. You'll have to check out this incredible interview he had about journalists in Minnesota and Iowa who are still advocating for and searching for Jodi Huisentruit, a broadcast journalist who disappeared in 1995. And then there's this interview with a friend of a domestic violence victim who was murdered in 2023 in Minnesota about what friends can do to be non-judgmental and supportive of those who are facing interpersonal abuse. You guys have got to check out this incredible podcast, Silver Linings Handbook. You can get it wherever you listen to podcasts. Yeah, no, I think that is a very, very important thing, the ex ante and post hoc, right? We can turn anything post hoc into when something happens either to your detriment or to your benefit. But you see those particular stages of the case, the law provides for certain things within that. You can plead guilty or not guilty at an arraignment, those sorts of things. Whether you can confess at any time. So that itself is not relevant for critical stages. And the important thing here, and I think this is why language is very important as well. When you said that we have a shared reality, we know certain things. For example, when we've talked about charges brought under the law and how child pornography, the law calls it child pornography. So we use that shared language, even though, some areas of the world use different words for that horrendous act. It's because in the law, we are all referring to the same claim that's being brought, the same actions, the same violations. So here too, everyone knows what happens at an arraignment. Quite literally, there's a checklist that the judge has to go through at these types of hearings because they are defined by the law what will happen there. So they're not willy-nilly kind of what happens at a plea agreement. We know exactly what happens at a plea agreement because when both of us clerked, I'm sure you were given one on one of your first days of clerking too. When we would do criminal cases, especially criminal cases, we had checklists for every one of these critical stages hearings because things had to happen. Certain questions had to be asked, say at a plea hearing, a change of plea hearing, where their plea could be invalid after the fact if certain procedures are not followed. Certain questions are not asked on the record. And so there is absolutely no surprise what's happening in those stages. And that's where counsel can be very helpful, because we know exactly where there could be potential rights that you'll give up that you cannot then ask for again later and say, I didn't know.
So some examples that are not critical stages, the courts have said are not critical stages for the purpose of this idea of you need to have a lawyer there. These things may sound critical to you in the common understanding of what that means. But as I said, this is a term of art. Grand jury. Obviously, there's had to be an attorney there. The defendant isn't even there. Probable cause hearing. That might be interesting to you, because that's where, if you're arrested on a complaint, if you're not indicted, where the prosecution is going to present all its evidence. You're present at the probable cause hearing. As Al said, you could jump up and say you did it, but that is not a place where you necessarily need an attorney. An interview with a probation officer. Pre-sentence, a request for consent to search. So the police show up at your house and like, hey, can we search your house? That's a really important, a critical moment for so many cases, because so many people say, sure, come on in, and they find the body. Right? But the courts have said, sorry, that's just not a critical stage in the meaning of the word as we're describing it. A pre-indictment lineup. So we talked about a post-indictment lineup. You have a right to counsel, but not in a pre-indictment lineup. Taking exemplars to compare for other evidence, fingerprints, handwriting, DNA. You don't have a lawyer when those things are happening. During a psychological examination, you don't get to have a lawyer in the room with you with a psychiatrist. Now, you do have a right to speak to counsel before the examination, so you sort of understand what's going to go on, but not in the room. And so many other examples of this. And so you need to think about, are these the circumstances that would fit in this sort of idea? Now, think about what this hearing was all about. This isn't a constitutional hearing, right? This was not a hearing where any of Richard Allen's constitutional rights were at issue. So he's been arrested. He's going to be detained somewhere. This is literally where we're going to keep him. We're going to keep him in the jail. We're going to keep him in the prison, right? Ex ante, beforehand, this is not the kind of circumstance in which you would expect someone to do or say something that's going to be detrimental to their defense. And we're talking about the actual hearing itself. Is what happens in the hearing something that is likely to be a detriment to you once you get to trial? Not like something that happens months later that you can tie back to the hearing. But is the hearing itself a place where something like this is going to happen? Richard Allen didn't have to say a single thing during this hearing. In fact, he would not be expected to say anything during this hearing. There's no way ex ante, beforehand, you would think, oh, wow, that's a critical juncture of the case. We need to have a lawyer there. And the other thing, which people who talk about this have to know, this is all subject to harmless error analysis, which means the error itself, like even if you don't have a lawyer, well, let's say you don't have a lawyer at the arraignment. Well, in Indiana, just like everywhere else, if someone realizes that, we can just do the arraignment again. And guess what? We've now fixed the error. It's not the error has been made and therefore nothing, we can never fix it, right? And in fact, in Indiana, in a lot of places, if you never raise it, so you know that the arraignment, there was an attorney there, and you go all the way through trial, much like, say, Richard Allen. And then after trial, you're like, ha, the arraignment, there was no lawyer there. Another bite at the apple. The Indiana Supreme Court has said, like most courts, no, you can't do that. You can't ambush people just to try and get another trial when you knew all along this problem was there. So you have that issue here. But the other big one, they had subsequent hearings with Richard Allen's attorneys to talk about the safekeeping order. In fact, they filed multiple challenges to the safekeeping order to the point that it was annoying. They did it like 3 or 4 times. They finally, on like the 5th time, the judge was like, fine, we'll send him to another county jail. So any harm that was done was remedied by those subsequent decisions. And this is minor and stupid and doesn't matter and it's not going to mean anything, but it's like a microcosm of everything that's wrong with this case, because so many people talking about this case lie to you in a way that you don't get lied to in other cases. Like Karen Reed, I had lots of problems with the way the defense attorneys did in Karen Reed. I didn't like the way they essentially were slandering everybody in Canton to try and clear her. But they never just ignored basic law in the way that I feel like the Delphi attorneys do. Even when they're challenging things where they're going to fail, they're couching it in terms of this is a way you could see the law that's favorable to us.
And a great example is that famous Franks motion, right? Where they wrote about Odinism. It had nothing to do with Franks. They know what Franks is. That was not a Franks motion. Listen to that episode if you want. But this is, I think, more pernicious because critical stage has we understand the word critical, we understand stage, and a layperson can be led to understand those words to mean something they completely do not within the law. That's why I think it's even more pernicious, because you can say Franks and nobody knows what Franks is if you don't practice within this space. But critical stage, they're basically using a legal term as whatever common phrase they wanted to fit their purposes.
I just want to give an example of the Karen Reed case. With the lawyers in that case, I thought are much more clever and honest than the Delphi case. We're going to talk about it in a minute. But you all remember this whole question of, did the jury actually render a verdict on 2 of the charges? Now, one way you could have gone at that is a double jeopardy claim. You say, look, double jeopardy because they actually found her innocent, so therefore you can't try her again. And actually, I think the reality is it kind of is a double jeopardy question, but they didn't do that, right? Because they knew the law was completely against them on that. There was no way they were going to get double jeopardy. So they actually did something a little bit more clever. They did this whole motion to dismiss the charges on the basis that it sort of was it was offensive to due process that she be required to once again face these charges where the jury had really found her not guilty. That was a clever, different way to approach it. But at least they're sort of working within the law. Right? It wasn't like in this case where they're just being completely misleading, where it seems like everything is directed at the public, not the courts. Because if it was directed to the courts, you would never make these arguments. You would make different arguments that had a better chance of success. And I don't know, just when Anya was talking about that whole shared reality thing, I was like, actually, there is a shared reality that we all operate in. The average defense attorney
somehow opt out.
Yeah, they just somehow opt out. Like I have a case, and the defense attorney today said that he's gonna move to suppress something. And if he were the Delphi lawyers, I would roll my eyes. I'm like, okay, good luck with that, because I know I have no faith in them, right? But with him, I'm like looking through the evidence to try and figure out what exactly his argument's going to be and how he's going to do it. And I know he's going to do it within the law. I don't have to dream up some dragon out there to slay like they do. And it's just, like I said, this was such a perfect little microcosm of what they do. I thought it was worth actually talking about it. Not going to talk about the rest of the motion because the rest of the motion is just like this. You can read it for yourself if you want to. But I really think when you hear news from Delphi, just remember that, because I feel like people freak out every filing in the Delphi case. And if it is from those 2 attorneys, now they got new appellate lawyers, so we'll see what they do. If it is from those 2 attorneys, you can almost be certain that they are attempting to mislead you in some way. And that what they're saying, even about the law itself, isn't true.
So that's the Delphi case. The case that I really wanted to talk about today, because I do think something significant has happened, something that a lot of people were hoping for, and that is in the Ellen Greenberg case. Ellen Greenberg was found dead in her apartment. Whether it was locked or not is actually a question. And she had 20 plus stab wounds to her chest, head, back of neck, and was ultimately found with a knife sticking out of her chest. And why this has been going on for so long, and I said she was found dead, is because the manner of death has been kind of the big fight within the courts, because no criminal charges have ever been brought, but her parents have been fighting for a proper investigation. Because if you remember, when she was first examined by the medical examiner, I think the first opinion, I honestly lost track at this point, was homicide was the cause of death. Then the medical examiner changed the cause of death to suicide. And her parents have filed a couple lawsuits, I believe, at this point, essentially trying to get that medical examiner's opinion to go back to the original conclusion that this was homicide or something other than suicide, based on all the things happening. And also there were attacks. These are all civil cases, by the way, attacks on certain investigators and the investigation itself of not being properly conducted to even know what happened. And so these 2 lawsuits actually were settled out of court. Both have been settled, but most recently, the judge granted did not grant summary judgment for the state, which meant that the case could go to trial. And instead of go to trial, they ended up settling out of court. So part of the reason for that is there's going to be some undisclosed sum, which is great because I think her parents have been fighting for this for more than a decade, probably used up all of their money in these lawsuits. Lawsuits are incredibly expensive, but there might be promise of a new investigation. And I think that's what is needed all along here, because Dr. Marlon Osborne, who initially categorized the death as a homicide, only to change it to a suicide, ended up signing a new affidavit with this recent filing. And it read, quote, "Since issuing the amended death certificate, I've become aware of additional information, and it's my professional opinion Ellen's manner of death should be designated as something other than suicide." He went on to say, "I am now aware that information exists which draws into question, for example, whether Ellen's fiancé was witnessed entering the apartment before placing the 911 call on January 26, 2011, whether the door was forced open, as reported, whether Ellen's body was moved by someone else inside the apartment with her at or near the time of her death, and the findings of Lindsay Emery, MD, from her neuropathological evaluation of Ellen's cervical segment sample." This is big. This is really what the lawsuits have been about. Now, this is not some like golden ticket. No one's thrown in jail now because the manner of death hasn't been changed officially. This is all like, technically the death certificate right now still says suicide, but the one who issued that amended death certificate basically says, now with more information, I would not say that this is a suicide. That's huge, because if it's a suicide, there's no crime and there's no investigation. Now, whether there will be any criminal charges brought is actually, that's far, I think a major battle has been won here by her parents. I think there's going to be an independent review board. Is that correct? Because the state had previously looked at it.
It's a little unclear exactly how the review is going to happen. And I will say this, I am happy that this occurred. I am skeptical. I remain skeptical. I mean, I commented on this on Twitter, but you have the governor who was the attorney general at one time, who after all this, it's just astonishing.
This is not the way to do a press conference, or this is not the way to speak to victims.
In the way of any investigation since he was attorney general. And after this happened, where you have the medical examiner who's saying, look, I didn't have all the information when I said this was suicide. And then he has a press conference where he says lashing out isn't going to change the evidence here about Ellen's parents. Like, that's his view on it. Apparently doesn't have any idea what the evidence is or about this change from the medical examiner. And if he is responsible for any investigation, then it's either not going to happen or we know where it's going to go. There's been talk of, various different agencies who could conduct some sort of new investigation. Personally, I think the Attorney General of Pennsylvania has to step in here. And I think there should be some pressure put on him to step in. That is the only agency that I would trust. I think his name's Sunday, the current Attorney General at this time, because I don't think you can trust Philadelphia. I don't think you can trust some neighboring police department because they have an interest in sort of supporting their friends in Philadelphia. I think you're going to have, if you can't have the FBI do it, and I just don't know if you could, you're going to at least need the Attorney General's office to look into it. And I think that's really all the parents are asking for. The parents have said they feel like it's a major victory just to have the medical examiner, the person who looked at her, finally agree that this wasn't a suicide. Now, as Alice said, this hasn't changed anything officially. He is no longer the medical examiner, so he can't change it. And in his affidavit, I think he even says, like, I
don't have that office. Right?
Exactly. I don't have that office. I don't have a medical license in Pennsylvania anymore, so I can't change it, but this is my position. And I think that needs to be taken seriously. And he echoes something that we talked about before. Multiple courts have looked at this, and even courts who didn't feel like they had the power to rule in Ellen's parents' favor because they didn't necessarily think they could do it, have said there are all these reasons this should be investigated. I just feel like independent people have been begging Pennsylvania to just conduct an investigation to the extent you can, to the extent that the mistakes made in the first few hours haven't rendered this impossible to ever know what happened. begging them to do this. And you have Shapiro, who instead of saying, why is this personal to him? You know, he's the governor of the Commonwealth of Pennsylvania. Why would he react that way? It is, frankly, bizarre. And he's a good politician. And I don't know, the whole incident made me question things, because a good politician, which he is, would never say something like that. Unless they let their emotions overwhelm their brains, they wouldn't say that. Why is he so emotional about it? Why is he so invested in it? Why not just say, you know, I'm glad the parents are getting an investigation, and all I've ever wanted was the truth, and I hope they get to the truth. We looked at it when I was Attorney General.
That's a very political answer, right?
Yeah,
like it says nothing and it commits to nothing, and it's very blasé. But you're right. I mean, he's a very good politician. And to hear, I mean, you see all the articles about it. Using those terms, lashing out, is a very offensive term, especially.
He said it twice.
Parents. He said it twice.
Twice.
And it'll be very interesting. But I do think public pressure here, because this is what they've been fighting for. It doesn't change the state of the case. Someone has to open it, right? The Commonwealth has to open the case and investigate and whatnot. They've done all they can, the parents, I mean. There's more pressure they can put on. They've succeeded, essentially, in the courts. I think it's huge. The one who amended the death certificate, short of saying, I was forced to, amend the death certificate, that would be even better. But they're saying, what I know now, I would not rule it as a suicide, is something I know they fought for since she died back in 2011.
And let me just say this. We know that public pressure can affect these investigations. We know it. We've seen it for good and for ill in the other cases that we've covered. And if you're in Pennsylvania, you need to be calling, tweeting, writing letters to Shapiro and to Sunday, letting them know how you feel about this. The governor, they pay attention to that stuff. The governor's tweeting all the time. Every tweet he makes, somebody should be responding. You need to look into Ellen Greenberg. Like, he needs to be hounded by this until he gives his full support for an independent investigation that goes wherever it goes. And we've been clear about this. We have never said this is definitely a homicide. We have never accused anyone of killing Ellen Greenberg. We have acknowledged that there is evidence of a suicide and that this may very well have been a suicide. All we've ever asked for, and frankly, all the parents have ever asked for, is an actual investigation into this case, looking at the evidence such that it is, so that we all can have answers. And that is the very least that Ellen's family deserves and that the people of Pennsylvania deserve. Because if this was a murder, then there's a murderer out there, and that person needs to be identified and arrested and punished. And I don't feel like that is too much to ask. I feel like it is the bare minimum to ask. That's my thoughts.
So there you go. No, I think that's exactly right. So if there is any update, we'll let you know. But this is where kind of some of you have asked, well, hasn't there been a lot of pressure in the true crime world? Sure. But now the people who can make a difference, the AG of Pennsylvania, that's who needs to be getting the phone calls and the tweets and the everything, right? These people do hear all of the public pressure, and that's where the attention needs to turn.
So then Karen Reed. So we've talked about Karen Reed before. Some of you may be familiar with her, vaguely familiar with her case, I'm sure. We talked about this filing earlier in this episode, and we have a couple episodes on this, or at least one, on this whole question of whether or not her mistrial is going to result in her being tried for all three charges that she was originally charged with, or whether some speculation about what the jury intended to do might result in her having two of those charges dismissed. And we told you from the very beginning there was no way that was going to happen because there wasn't actually any verdict, and we cited to you all sorts of law, part of that shared universe. Her lawyers, they fought the good fight. They lost in the trial court. They lost today in the Massachusetts Supreme Judicial Court, who ruled unanimously that you can't do what they're asking to do. There's been no jury verdict, so therefore there's no basis for a dismissal. And I mean, a lot of really interesting language, including in the footnotes, a few shots at the defense in the footnotes. You can always read the footnotes. So if you're keeping score out there, I don't have our list, but we need to add 7 more people to the conspiracy, the 7 members of the Supreme Judicial Court, who clearly are also a part of the Canton Mafia and are subjecting this poor innocent woman to another trial on these baseless allegations that have been made against her. I weep for Karen Reed.
The conspiracy grows. The
grows
head
every
count
day.
grows.
And
It grows
look,
every
and I
day.
wish I was joking. I wish I was joking. But if you go on Twitter, there's already people. She needs to appeal to the United States Supreme Court. As if if the United States Supreme Court takes this case, it will only be to make very clear that you can't do this. That is the only reason they would take this. They've done it in a civil case. This is an opportunity to do it in a criminal case, so maybe they will take it. But she's going to lose.
I was just about to say, but they won't because it's so obvious.
It's so obvious. Yeah. I mean, I don't know. It's just funny. This is another one. Like I said, I thought their argument was at least a little clever, but it was obviously always going to lose. Jessica, who's one of our researchers, and many of y'all know from the gallery, was fighting, not a lawyer, fighting with all these people on Twitter when this was coming up and citing all these cases about why you can't do this. And it's just, you don't even have to be a lawyer to understand this is never going to succeed. So once again, just because a defense team files something and cites a few cases doesn't mean it has merit, doesn't mean it's going to succeed. We're not talking about the Koberger case here because we don't have the final ruling yet, but the motion in the Koberger case to suppress the DNA because you have a privacy interest in the DNA you leave at the crime scene, as we said in a prior legal briefs, is also going to fail. Somebody had posted about that on the gallery recently, about how they were so concerned that that was going to result in dismissing the case. It's not going to. The thing about the law is it's usually pretty self-evident. There's confusing aspects of it, but if something strikes you as just crazy, like how is that possible? It probably isn't.
That's right. Well, those are updates on 3 cases, but those are kind of the hot 3. It keeps changing what the hot cases are. I'm hoping that we get some other cases we can focus on very soon.
We need some new blood.
We need some new conspiracies to shoot down.
Exactly.
But we love talking about these things because you guys have questions. We love diving into them and, kind of dissecting where the confusion comes from as well. Because I think that's really important to know where the confusion comes from so that you can be on the lookout in the future. You teach a man to fish. You can spot these sorts of inaccurate reportings in the future yourself, but we're always here and happy to talk about them. Let us know what you think about these. I'm sure there are lots of strong feelings about it. Let us know what you want to hear about. You can always email us at prosecutorspod@gmail.com. And you can find us on, Twitter, Instagram, Facebook, TikTok. There's that one as well. We read all those comments and we do love hearing from you because this show is really based on what listeners want to hear. Brett, is there anything else you want to add about any of this?
The only other thing I'll say is if you're out there and you're trying to understand what's going on in these cases and you see people who are trying to sell you things, who are trying to sell you that where someone's going to be confined is a constitutionally critical stage, or that it is so obvious that Karen Reed is going to succeed because she clearly was acquitted of those 2 counts, who put themselves out there as lawyers, who claim to be lawyers, who are trying to explain things to you. And they're always telling you it's so obvious it's going to go one way, and they're always wrong. Everybody gets stuff wrong every now and then. And there are close questions. But in these 2 cases in particular, just over and over and over again, you're seeing these same people tell you how things are and what the law is, and they're just always wrong. Maybe consider not listening to them because they are, especially if they get you worked up, they're adding to your anxiety level, and you have plenty of reasons to be anxious in life. So cut that out. You don't need it. That's my take.
That was like a BetterHelp ad.
Yeah, there you go.
I love that take. Well, do we have time for a question today?
Oh, sure. Why not?
Look at us being under 45 minutes-ish.
Alice, if you got time, I got time.
I got time for y'all.
And you got time. So, yeah, I mean, sorry to rant. It's just, I don't know.
It's a worthy rant because you see the damage it does. We've talked about this. We don't need to rehash this again. But I do think people go to the news, all the different outlets of news that we have these days. It's not always your typical news articles, YouTube, other podcasters, us even. And I think unnecessarily kind of riling people up for your cause when it's not rooted in the law or facts is not responsible journalism. Not responsible podcasting. We're not responsible YouTubing, whatever you want to call it. And like you said, we have plenty to be anxious about.
We do. Okay, let's see. Let's see what this one says. Oh, this is interesting. Okay, so this is from Linux, and Linux says, as I understand it, this is a really good question. Linux says, as I understand it, a lot of cases are decided based on precedent set from an earlier case. But must the judges moving forward base his or her decision on the precedent-setting ruling? What if the current judge don't agree with earlier precedent-setting ruling? How much latitude do they have to rule differently?
Very
I feel like that's a
good
whole
case.
legal brief.
Yeah.
argument, or a whole legal brief episode. Have we done one on precedent? I think we did.
I think
didn't
we have. We've talked about like dicta, and so we've talked about stare decisis, right? So that's a really, really good question.
We'll just talk about it again.
We could talk about it again. So there's civil cases, there's criminal cases. Obviously, the facts, you don't have a predetermined case for any case. The facts do matter within a case. With that said, when you're just looking at the law and how to say, define what a critical stage is, for example, it depends what the binding precedent is. If it's a court that you must submit to, so a higher court than you, so if you're an appellate court or a district court and the United States Supreme Court says something, you do have to follow it. But if a sister court meaning you're on the same level, they're not above you. So if you are in, say, a district court, I'm talking about like federal district court in Georgia, and there is a question that has not been answered by a higher, like the United States Supreme Court, but there's a definition of a term by, say, a district court in Alaska. That's a sister court that you can find persuasive. You don't have to follow their precedent, but you can take their reasoning to inform your own reasoning. And you can disagree with them too, based on whatever their reasoning is. You're not bound by what they have done. The district court obviously usually has an appellate court on top of it, and then the Supreme Court. That's kind of a broad strokes as to when you need to follow precedent.
So we do have an episode, number 9 of Legal Briefs, called The Law of Precedent.
Wow,
so check
look
that
at
out.
that.
I can't remember,
Right in the beginning.
what we said, but I'm sure it was brilliant. No, everything Alice said is true. I think the simplest way to think about it is if there is a court that's above you that has ruled on the specific question before you, you have to follow them. And as Alice said, the facts are always going to matter. So here's an example, a simple example. Someone is being interrogated by the police. They say, I want a lawyer. And the police say, we don't care what you want. Answer our questions. Right? And then he confesses to the murder. If that goes before a district court judge or a trial court level judge, that judge is bound to suppress that statement because the law is very clear and precedent is very strong that once you explicitly request a lawyer, questioning has to stop. And that didn't happen in this case. So if the judge says, you know what, I know precedent says that, but Miranda was a stupid ruling and I don't care what it says, I'm letting the confession in. Okay, let's say they do that. The defense attorney then is immediately going to appeal to a higher court, an appellate court. Now, the appellate court is bound by all, say it's the 11th Circuit, just because that's the one that I'm in front of all the time. So the 11th Circuit is bound by Supreme Court precedent and by prior decisions of the 11th Circuit. So if you're 3 judges and you get this question and there's an 11th Circuit case before that says you have to suppress this, or there's a Supreme Court decision that says that you have to suppress this, you're supposed to suppress it. Now, you can say in a concurrence, I think the law was wrongly decided, it needs to be redecided, but we're bound to do this. And you see that a lot in appellate decisions, where appellate courts will say, because of this binding precedent in our court, or this binding Supreme Court precedent, we're required to rule as we are, but you should overturn it. You then appeal it up to the Supreme Court. The Supreme Court is sort of, by tradition, bound by precedent, but because they're the Supreme Court, if a majority believes the precedent was wrongly decided, they can overturn it. They have various factors they consider in whether or not to do that. Miranda, which we're talking about, was challenged again some 20 years afterwards, I think in a case called Dickerson, maybe. Dickerson, I think that's right. I don't know. I may just be making that up. But it definitely was challenged. And even one of the justices who had been calling for Miranda to be overturned for a very long time, in that case was like, look, it's just become too foundational. Can't overturn it. It's going to remain, right? So the Supreme Court could overturn it. An appellate court, if you have those 3 judges and there's no Supreme Court precedent, but there's another appellate decision, they can say, hey, we need to go to something called en banc review, which is the entire court, the entire circuit court. It can overturn a prior circuit precedent. So the entire court could say, you know what, we got that one wrong 20 years ago. Those judges were idiots. So we're going to reverse that and move forward under a different thing. So precedent is really important, but only certain precedent is binding. The rest of it, just other decisions are, as Alice said, they're persuasive. Another learned lawyer looked at this and thought this. So if I'm going to disagree with that, I should at least explain why. right? But it's not binding in the way that a higher court ruling is. So that's a great question.
It's a great question. If it's not by a law student or a lawyer, way to go. You probably understand the law better than most lawyers.
Excellent question.
That's a great question. Well, thank you guys for writing in your questions. Reminder that if you leave a 5-star review, you can ask us a question, any question. We don't even really limit you to one question. We are very relaxed here, but we love hearing your questions. They can be about the law or anything that's on your mind. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. All right.
Hello, everyone.
Yellow.
I have this massive bottle of Topo Chico tonight.
Wow, that is big. Those are like the ones they bring you to your table when you're in like a European country.
Exactly.
You know, it's supposed to be for the table, not for one person.
Exactly.
I never understood that though, because we would drink like it's only one round, and then
I
it's
need
gone.
like 50 of those things.
Yeah, I know. I'm always
That's
like,
one of my favorite
"Mas,
things about
por
Europe,
favor."
though. I love a big
Bubble water.
bottle of con gas.
Con gas, con mucho gas, and they like that's always my joke. They don't get it.